Who doesn't like a good little Second Amendment gun discussion? And the Florida laws keep coming out. We're getting more and more cases that are talking about what right do you have to possess a firearm in Florida under the Second Amendment when you have a prior conviction for a felony anywhere in the United States. I've gone over the Range case and the Bruen case. You can dive into that analysis by just clicking around on the screen somewhere. But what I wanted to talk to you today is about a new case here in Florida called Fleming versus the state of Florida. First of all, they're going to quote Range, and I'm going to quote their quote so that you can understand where some of the confusion lies for those of you that have felonies, but you want, to bear arms like everybody else. Second Amendment, we the people, you're part of the people, right? And the Range versus Attorney General case from last year, that federal court said, look, the record contains no evidence that Range poses a physical danger to others. It was a nonviolent felony for Range. Because the government has not shown that our republic has a long-standing history and tradition of depriving people like Range of their firearms, 18 U.S.C. 922, the statute that outlaws felons from possessing firearms, cannot constitutionally strip Range of his constitutional rights. Bam! Range is a convicted felon, but on that case, he gets to possess firearms again. The Second Amendment applies to him. He has the right to bear arms, even though he's a convicted felon. Well, now you've just kicked the hornet's nest, right? And everybody is calling me and people like me and saying, I know I'm a convicted felon. I want my gun rights back. Now let's focus on Florida. How is Florida approaching these things? Well, I've already done some videos on this, and Florida not buying into that. Florida has said in no uncertain terms that convicted felons in the state of Florida are not getting their rights back. I mean, well, you can get your rights back through clemency. A lot of people do that, but not the way that the United States Supreme Court issued their ruling in Bruen and the federal district court in Range. So let's take up Fleming. Now here's Fleming. 13 years ago, this Fleming guy gets a felony conviction, and it's a non-violent conviction, right? So he's got this non-violent felony that's 13 years old, and then he gets caught possessing a firearm. He moves to dismiss in the Florida case, and he argues pretty much Range and Bruen, which say, look at the historical context of felons possessing firearms and whether historically the Second Amendment allowed felons to possess firearms back in the day. Fleming argued, we used to be able to possess these things. Florida court, will you let me possess a firearm even though I'm a convicted felon, but I'm a non-violent felon? Court's not buying any of that. And the Fleming court really is consistent with some of the other Florida courts that I have other videos on. Maybe I can fly them around the screen for you and click on those. But other Florida courts have held that if you are a convicted felon, we don't care if it's non-violent, you don't get to possess a firearm unless you jump through the clemency hoops, of course. So here's what the Fleming court said. Part of their reasoning is that there is binding precedent from the United States Supreme Court that requires us to deny Fleming's request. And they cite District of Columbia versus Heller, which I have done another video on Heller. But Heller, here's the quote from Heller. Nothing, in our opinion, should be taken to cast doubt on the long-standing tradition, long-standing prohibitions on the possession of firearms by felons. That, my friends, is the United States Supreme Court saying it's a long-standing prohibition on the possession of firearms by convicted felons. But folks, I am sorry to report to you, if you were getting your hopes up because of Bruen, well, Florida is not budging on this. And this Fleming case is just another one in the line of cases where Florida is saying, convicted felons, I'm sorry, you can't possess. But I will keep you posted because you never know. Maybe that right case comes along and this would change. I really thought Fleming with a 13-year-old non-violent felony might have had a shot at this, but he got rejected, folks. That's my update for today. And if you get in any trouble here in Central Florida, you know that's where I've been doing this for over 30 years. Please give our office a call, or could you subscribe? Could you like something, heart something? That helps us out too. Thanks for watching.